Hello, good morning. I'm Joe Wallen.
And I'm Susan Shalla.
Nick has asked us to be here today to talk about non-disclosure agreements, confidentiality agreements, and IP assignment agreements.
Right, so probably the most important thing when you start hiring employees or consultants to your company is to have them assign their intellectual property rights over to your company. So anything that they work on after that, there's no question that it belongs to the company and that they can't take it with them if they were to leave the company.
Right, and this is a big, this is one of the sort of big mistakes we see some companies make, which is they don't get people on the right paper. And so if it's an employee, you're gonna want the person to sign an at-will offer letter and an employee innovations proprietary rights assignment agreement. If it's a contractor, you're going to want them to sign an independent contractor agreement with confidentiality IP assignment provision language in it. Yeah. If they're a board advisor, you want a good board advisor agreement with similar language. Anyone who provides services to the company has got to have a really good, solid document relating to intellectual property. And if you don't have that with every single person who's ever worked for your company, that's a problem.
That can come back to bite you. So what we've seen is in the context of the company raising additional funding from outside investors, or at the point where it's going through a merger and acquisition transaction, the other side to that will ask, do you have these intellectual property assignment agreements from every single current and former employee and independent contractor? And the situation that we've encountered is, yeah, there might be like one or two or three people out there that never signed one. And even if they've left the company, you know, do you have to go chase them because these people are, you know, requiring that as a condition to either the funding or the acquisition? And we've chased those people.
Yeah, we've had, one thing to keep in mind, I mean, when you're a startup, I mean, there are certainly things you do as a startup from a legal perspective that are less intense than what a big company would do, because you're not a big company, and so you have less concern about being a target, maybe, perhaps. However, like, if you're going to be bought by a big company, the big company is going to come in and apply its analysis of its position on issues to your business. And then if you don't have IP assignment agreements from everybody, they're going to make you go get them.
Well, that's a risk to them. They think that leaves them, you know,
exposed. It certainly does, yeah. For a big company, I mean, even for a small company, you just don't want to leave any holes. And what I tell people about your startup is, hey, think of your startup as a ski hill. Okay, let's say you owned a ski hill, and you wouldn't let anyone take the lift rope up the hill until they got the right paper.
Right.
They got to
sign the waiver.
They got to, in the ski hill context, sign the waiver. In the employee or independent contractor working for a startup context, you got to sign the right IP assignment and confidentiality provision documents.
Yeah, and you can imagine, you know, when you are chasing these people that have left your company years, you know, a year or two ago, they're going to say, well, what's in it for me? I mean, I know you want me to sign this thing now, but they may extract a little pound of flesh at that point.
Yeah, I had a transaction, I'm not making this up, we had a company that they had a negotiation with a prospective CTO, and they came to a verbal agreement, hey, you're going to work for us and X percent of the equity and this many dollars. All the legal documents were generated and sent to him. And then the CEO and the CTO sat on the documents for about a month and didn't pay any attention to what was going on. And then the CTO said, hey, I can't do this deal for the percent we talked about. And then the CEO said, well, what percent do you want? And there was a much bigger percent. And the CEO said, well, that wasn't our deal. Right. And so ultimately the relationship between these two people just dissolved, and this person went away and refused to comment or respond to emails. Right. And so we ultimately just sent a letter saying, wish you the best in the future, and then we took all the work, that code the person created, we quarantined it, we didn't use it. And then 4 years later, we sell the company, and the buyer says, you got to go get a document from that guy.
Yeah, that's the worst.
And so that could have been a shakedown situation.
Yeah.
Horrible situation.
Yeah.
So you just want to avoid setting yourself up to potentially be shaken down by somebody. And we've done sale transactions where we're selling a company, but we spend the entire month before the sale negotiating settlements with people who have claims against the company.
Clean up, to get
claims,
that ready.
Yeah, claims related to, oh, you promised me equity, oral promises for equity, and things like this that you don't want to do
Right, so yeah, but the IP assignments are one of those critical documents that you need signed by everyone who touches the intellectual property of the company.
Yeah,
And
that's right.
It has, at least the way we draft it, it also has confidentiality provisions in there. So it covers everything that you want your employee to sign up to. So they can't then go, spill your trade secrets to anybody else.
At least without
At least without you having the ability to enforce that contract.
Right. So the big lesson for today, I think, is for service providers to your company, just make sure you get them on the right paper. If you ought to probably, if you're starting a company, be working with a law firm, and they ought to have that paper done. And so you could call them and say, hey, send me this stuff for this type of. I'm going to bring on a contractor, some of your contractor agreement. I'm going to hire an employee, some of your employee documents. And we're happy to share with you our standard form documents if you like. A lot of times, like in the hire context, the first time you do your offer letter and your employee innovations agreement for your company, there's some customization involved in that first go around.
Right.
But then once you've got it done, it's just basically stamp these out identical for each successive employee.
Yeah, I guess one other thing that we should talk about is exceptions that people can call out on that IP assignment.
Sure, so this is
agreement.
important, and it does cause a lot of confusion. The documents are set up so that if somebody has some sort of intellectual property that they want to exclude from the company's ownership, that people can schedule those.
Right, that exclusion. So if it's something that has nothing to do with what you're doing in the company, that's usually pretty clear cut.
Right. Yeah, usually the document says, hey, I'm going to assign all intellectual property related to the company's business to the company unless there's an exclusion for prior inventions on Schedule A.
Right.
And so, but in any event, so there's a methodology there for people who are coming on to a company who have a bunch of prior patents under the name. By the way, if their prior patents were not all related to the business, then I don't think you'd need to schedule them as the way these documents are set up.
Right.
But,
although people do, just to make it very, very clear.
Sure.
Yeah.
I think that's right.
So.
Any other further comments, Susan?
No, I think that's it.
You think we talked enough about this? Okay, well, wonderful. We're glad you joined us this morning, and look forward to talking at noon.
Thanks.
Take care.